Good afternoon, everybody from Hong Kong, and welcome to the 10th webinar in HKIAC series. Today's webinar is on protecting your domain name, HKIAC Insights. Today's webinar will be in 3 parts. The first 3 parts will consist of 3 short presentations, and the last part will be a discussion time dedicated to your questions. So please send in your questions through the messenger function. Let me first introduce our 2 guest speakers today. First, we will hear from Eugene Low, who is a partner at Hogan Lovells in the Hong Kong, China, and Vietnam IP and TMT practices. He began his career as an IP litigator, and his practice has expanded to cover the full spectrum of contentious and advisory IP and TMT work. And by that, I mean technology, media, and telecommunications. And that crosses Hong Kong and China, and it includes copyright, patents, trademarks, and domain names. He also serves regularly as a domain name panelist and as an arbitrator and mediator. So we're very happy to have Eugene with us today to bring his long-held expertise. He's going to explain to us what domain name dispute resolution is, why it's important, and how the process works. Our second guest speaker is Dr. Shaila Ali. She's a professor and associate dean at the Faculty of Law of the University of Hong Kong. She has studied and practiced in China, in Hong Kong, Israel, the US, and Switzerland, and she speaks Chinese, English, and Farsi. She previously worked as an attorney with Baker & McKenzie in San Francisco, where she focused on international trade, corporate transactions, and regulatory compliance. She serves as a domain name dispute resolution panelist, a bilingual panelist, and also as an arbitrator and a mediator. And she's going to speak to us today about the key elements to satisfy the legal test for a successful domain name dispute resolution application. And finally, I should have introduced myself at the start, Sarah Grimmer is Secretary General of the HKIAC. I will provide information from HKIAC's perspective as a domain name dispute resolution service provider. And once I've finished, we will then have a discussion session and turn to all of your questions. So without further ado, I will now hand over to Eugene. Thank you, Eugene.
Thank you very much, Sarah, for the kind introduction. And thank you to HKIAC for inviting me to this panel. Today, I wish to give you an update of the domain name dispute resolution system, what it is, why do we consider domain name dispute resolution, and how do we do it in practice. Next slide, please. I hope this table will give you a snapshot of the key stages in a domain name dispute resolution scenario and the key players involved in domain name dispute resolution. First, we start with the domain name in dispute. And here I have given you a real-life example of a domain name case handled by ADN DLC. The domain name is starbucksx.com. The domain name was registered by an individual called Fan Jianyong with an address in China. And that person is the domain name registrant. And then we have the trademark owner in this case, which is Starbucks Corporation. Starbucks Corporation is the trademark owner of the brand Starbucks, and Starbucks Corporation has a number of trademark registration for that brand. Here, Starbucks Corporation considered that the domain name starbucksx.com has violated its trademark rights. So Starbucks Corporation submitted what we called a domain name complaint. The complaint was then processed by the domain name dispute resolution service provider. And in this case, the service provider was ADN DLC. The next And then next, the respondent, which is the domain name registrant, had a window to submit a response to the domain name complaint. And after that, what ADN DLC did was to appoint a domain name panelist to decide on the case. The domain name panelist is essentially an adjudicator of the dispute. So here, the complaint was submitted on the 23rd of April 2018, and the domain name panelist issued a decision on the 28th of May 2018. So the decision came out just over a month after the filing of the domain name complaint. And in this case, the decision was to require the domain name to be transferred to Starbucks Corporation. In other words, Starbucks Corporations won the domain name complaint. So the final stage of the domain name resolution system is that the domain name registrar is required to implement the decision by registering the domain name in Starbucks Corporation's name. Next slide, please. There are variations to the different stages and the players involved in domain name dispute resolution. And here are a few examples. One is the domain name categories. Just now, the examples concerns the .com, concerns a .com domain name. And of course, there are other what we call traditional domain names such as .com, .net, and .org. There is also another category which we call country-specific or place-specific domain names. Examples are .cn, which refers to China, or .hk, which refers to Hong Kong. We also have a new category of domain names, which we call new GTLDs, top-level domain names. Examples are .club, .xyz, and .zaixian. And with the different domain name categories, there are also different domain name dispute resolution rules. You might have heard of the name UDRP, which refers to Uniform Domain Name Resolution Policy. And this applies to disputes concerning domain names categories such as .com, .net. And the example I gave just now on StarbucksX.com applied this UDRP rules. We also have some slightly different rules on country or place-specific domain names. Examples are CNDRP, which governs domain name disputes of .cn. We also have HKDRP for .hk domain name disputes. There is also a slightly different set of rules called URS, which is a Uniform Rapid Suspension System. And that is a new dispute resolution system applicable to new GTLDs. Finally, there are also different domain name dispute resolution service providers. I gave the example of HKIAC and ADN DLC. There are also other service providers such as CTEC, WIPO, and the forum. Next, please. The main features of domain name dispute resolution, one main feature is that it is a paper-based dispute resolution system. The rules do provide for the possibility of in-person hearings, but in-person hearings are extremely rare. And personally, I have never come across in-person hearings in the domain name dispute resolution field. It is also a relatively quick process. usually we are talking about a time frame of a few months, like 3 to 4 months. And actually in the example I just gave, the trademark owner obtained the decision in just over a month's time. There are costs involved in domain name dispute resolution. The service provider would usually charge a fee, and that fee would cover the panelist fee as well as the service provider's own fee. As an example, ADN-DLC charges $1,300 US for a single panelist case for a dispute of not more than 2 domain names. In domain name dispute resolution, lawyers' involvement is optional, although many parties would benefit from involving an experienced practitioner. Another feature of domain name dispute resolution is that the success rate for complainant is pretty high. And we are probably talking about over 80% to 90% of the cases are in favor of the complainants. So that makes domain name dispute resolution a very attractive option for IP owners. And in terms of the decision that the IP owner can get, essentially the system doesn't involve any monetary award. If the trademark owner wins the domain name complaint, it will get back the domain name. So it's the transfer. The domain name panelist will order the domain name to be transferred to the trademark owner. In some cases, the panelist might order the domain name to be canceled. And of course, if the complaint is unsuccessful, then the panelist will dismiss the case. One slight variation to the remedies that the trademark owner can get is under the URS, the Uniform Rapid Suspension System. Under URS, if the complainant wins the case, the panelist will order the domain name to be suspended for a period of 1 year. And finally, domain name dispute resolution usually does not preclude the possibility of court appeals. One exception is the HKDRP, the .HK rules, which is stated to be an arbitration in nature, and the decision under HKDRP will be considered final and binding. Next slide, please. So why do we care about protecting domain names in the first place? One major reason is that domain name is an important IP asset. You might have read from news from time to time that domain names are sold or transferred for a substantial amount of money. I have given you 2 examples here, and I'm sure you can find more just by a simple internet search. Another major reason of protecting domain names is to tackle misuse. I have given 2 examples here. One is that people might register your brand name as a domain name to operate some fraudulent websites. And for those of you in Hong Kong, you will be very familiar with the names of these shopping malls. Again, these are real cases handled by HKIAC and ADN-DLC. And what the domain name registrants did in these cases is that they operated scam shopping websites under these confusing domain names. Another type of misuse would be counterfeiting websites. And again, I have given an example here. So protecting domain names is very important for building and protecting your brand. And also in this age of e-commerce and e-payment, it is it is critical to protect your domain name in order to maintain customer trust. Next, please. Just now I mentioned that usually domain name complaints do not preclude the parties from going to the court. And of course, for a trademark owner or IP owner, there are other options that they can consider to enforce their rights. Some common options would include sending a demand letter or sending a cease and desist letter to the other party. Another option would be going to the court, and I will I will compare civil lawsuits with domain name complaints in my next slide. The parties can also negotiate. They can negotiate a deal to transfer, to sell the domain name. And that's why sometimes you read in the news that, a certain brand owner agrees to buy back a domain name for how much money. Sometimes the IP owners may also complain to authorities or complain to service providers. For example, in cases involving fraudulent transfer of money, then the trademark owner might complain to the police. And in some other cases, if the domain name is used in violation of the rules and policy of a domain name service provider, then the trademark owner might also complain to the service providers to request the domain name to be suspended. And also, one other option would be to do nothing and just wait for the expiry of the domain name. Next, please. Thank you. So here is a comparison chart for domain name complaint on the one hand and civil litigation on the other hand. For domain name complaint, the scope is pretty confined. A domain name complaint is confined to domain name disputes and what we typically call cyber squatting. Whereas in a civil litigation, it can cover a wider scope. So if the other side has has registered a confusing domain name, but it has also conducted in other trademark infringement activities and passing off, then in civil litigation, you might be able to combine all these different grounds of complaint. Whereas in a domain name complaint, you can only complain about the cyber squatting bit. The second feature would be, as I said, domain name complaint is pretty much paper-based, whereas for civil litigation, usually some hearings would be involved. In terms of time frame, domain name complaint is usually quicker than civil lawsuit. And civil lawsuit, the timing can be quite difficult to predict. In fast-track cases, such as default judgment or summary judgment cases, we might still be talking about at least half a year. Whereas if the case is complicated and goes all the way to a full trial, then we might be talking about a time frame of 2 to 3 years. And in terms of the process itself, domain name complaint is pretty straightforward. The complainant files a complaint, the other side has a chance to respond. That's pretty much it. There is no discovery process and there is no exchange of evidence. Whereas for civil litigation, in common law jurisdictions such as Hong Kong, there is an obligation for both parties to disclose and exchange all relevant evidence. Finally, in terms of remedies of winning the case, the domain name complaint would involve a transfer or cancellation of the domain name, whereas for civil litigation, there is a wider range of remedies available. And in civil litigation, usually the winning party might ask for an injunction to stop the other party from using the domain name or the infringing trademark in question. And very often, the court would order some monetary compensation, either in the nature of damages and in terms of compensation of legal costs. Next, please. Before I turn over the slides to Sharla, I just want to mention two recent hot topics in the domain name field, and I'm sure some of you would be very familiar with these news. So the first one is who is search? Who is search against is a very popular acronym in the domain name world. And that refers to a search that can tell you the identity of domain name registrants. So how did who is become a hot topic in the domain name dispute resolution world? That is because traditionally a who is search would allow you to find out who is the domain name registrant. Just like in the Starbucks case I mentioned, the trademark owner could have easily done a who is search to find out that, oh, that Chinese individual was domain name registrant. What has changed now is under the GDLP, the General Data Protection regulations implemented in the EU. After the implementation of GDLP, a lot of the domain name registrants' personal data are no longer publicly available on who is search. So that presents some challenges for the complainant of potential domain name complainant to ascertain who indeed are the domain name registrants. Right now, there's no standard solution for domain name complainants to overcome that hurdle, because essentially that involves the balance of the enforcement of trademark rights and on the one hand, and on the other hand, the privacy rights of the domain name registrants. So people now turn to a few options in order to find out who might be the registrants behind the domain name. One option is to look at whether there is a related website, so that which might be able to give you some hint on who the domain name registrant is. The other option is sometimes domain name complainants might write directly to the registrar to request information, and very often the complainant would justify their request by giving the registrar some evidence of trademark infringement or abusive use of the domain name. And the final option is you just go ahead to submit a domain name complaint. And what the service provider like HKIAC or ADNDRC would do is that they would require the domain name registrar to disclose the real identity of the domain name registrant. And if eventually the domain name complainant finds out that, oh, actually this person has registered a few domain name that the trademark owner wants to complain against, then he or she can request amendments or consolidation of the complaints. Next slide, please. And the other hot topic is some good news for domain name complainants for .cn and .zhongguo domains. And it's quite a peculiar feature under CNDLP that there is a time limit of 2 years for domain name complaints to be submitted. But the good news is that since June 2019, this time limit has been expanded to 3 years, which is in line with the new limitation period under the civil litigation rules in China. So under the new CNDLP, complainants would have a longer time to file a domain name complaint. So that concludes my presentation. I will now turn over to Dr. Ali, and thank you again for listening.
Thank you very much, Eugene. So I'll now hand over to Dr. Ali.
So, well, thank you very much to Sarah, to the HKIAC, and also to Eugene for that great background on filing a domain name complaint and the overall structure of the system. What I'm going to do today is go into a bit more detail about the particular elements that need to be established to make a successful claim. So we could go on to the next slide, please. Okay, so I think this has been covered, but really what Eugene was sharing and also the sort of rationale behind setting up the domain name dispute resolution system is really efficiency. It's also reducing cost time of other options. As Eugene mentioned, there are other options, but this really has been shown to be the most sort of speedy and efficient method for resolving these claims. And as was mentioned, HKIAC does provide for proceedings for a number of top-level domains, and these are among some of the examples. We can go to the next. Okay, so what is needed in terms of establishing a claim? There are three key elements. So the first is that the registrant's domain name is identical or confusingly similar to a trademark or service mark, either in Hong Kong, in China, wherever it's registered, in which the complainant has rights. And that the registrant at the same time has no rights or legitimate interests in respect of this domain name. And finally, the registrant's domain name has been registered and is being used in bad faith. Next slide. All right, so the first thing, and I don't talk about it here, but I think an important sort of preliminary step is for the complainant first to establish its trade name registration. So that's very important in establishing its own rights to the trademark. It's much more straightforward if a history of trademark registration can be provided. Common law rights can be described, but that's a bit more complex. So that's the first sort of preliminary foundation. Then we get to identical or confusingly similar. So generally, this is what one needs to establish here is that this domain name is similar to the one in which the complainant has rights, and that the .com, .cn, etc., these don't confer any distinctiveness. As there's numerous case law that shows that this sort of .com, the final bit of the domain name, has no real significance. We could go on to the next slide, please. A few other things which have no significance is the geographic terms. So if you say IKEA, Hong Kong, or as Eugene gave the example, IFC Mall, HK, place name doesn't alter the underlying mark to which it's added. So once you have that mark in there and you add a place name or a geographic term, that's not going to alter the significance of the underlying mark, which is in dispute. We can go to the next slide, please. Okay, and in addition to the location, in some cases, individuals will use descriptive terms. So we saw in the past discussion, shop being used, sometimes bank. Some of the cases that we'll go through are things that I've been involved with, or reference other cases. But bank, for example, adding bank to a trade name is not going to distinguish that name. Similarly, using telecom, another descriptive term, does not distinguish the underlying trade name. We could go to the next slide, please. Okay, similarly, we get now to the next element, which is that the registrant has no rights or legitimate interest in that domain name. So, for example, this could be established by the complainant showing that it has no prior connection with this respondent, nor has it authorized that respondent to use its trademark in this way. At the same time, there can be a showing that the respondent is using this domain name for various means that may not be sort of on the up and up. So these are some of the examples. Using the domain name to attract visitors for a website with misleading or infringing content. For example, counterfeit products that even reveal the trade name that is in dispute. Also linking to other sites, gambling websites, sites with adult content, or even inactive sites. These are potential indicators of no rights or legitimate interests in the particular domain name. Okay, we could go to the next slide, please. And again, just simply registering a site is not sufficient by itself to prove that the registrant has legal rights in that domain name. So again, just the mere registration is not sufficient for a showing of rights. We can go to the next slide. All right, so bad faith. This is another, the final sort of element. And here there are a number of prongs. ICANN has set this out in the UDRP, which is a number of circumstances that together constitute a showing of bad faith. And so the first of these prongs is circumstances that indicate this domain name is being used primarily to sell or rent or transfer this domain name registration for valuable consideration in far excess of the out-of-pocket costs directly associated with that domain name. And then the second is to prevent the owner of the trademark or service mark from reflecting that mark in the corresponding domain name, and that there is a pattern of this kind of conduct. The third sort of sub-prong is that the purpose of this registration is primarily for disrupting the business of a competitor. And then finally, by using this domain name, there's an effort to attract for commercial gain internet users to your own website by creating this likelihood of confusion. So finding a well-known mark that attracts a number of high level of interest and directing users to content which has nothing to do with that trademark. We can go to the next slide here. All right, so here in the next couple of slides, we're going to look at a few examples of bad faith. So one of the elements that's often examined is to what extent could the respondent have been aware of this complainant's use of the disputed domain name? Largely what's looked to here and what's established in the complaint is the reputation of this trademark. So evidence of sort of media and its sort of worldwide scope, its reach, customer base, etc. These all help to establish the extent to which the respondent should have or could have been aware of the existence of this trademark based on its overall global reputation. Below are some examples of respondents. Largely what's looked at is the domicile of the respondent, where they live, and whether or not that trademark has reached sufficient level of notoriety or high level of regard by the general public in that region, and whether that respondent should have been aware of the existence of that trademark. We can go to the next slide, please. All right, so again, another element or another sort of prong in establishing bad faith, or an example, is featuring the trade name with related products. So for example, IKEA, there was a case where IKEA a respondent was using the name IKEA in a infringing domain name and selling counterfeit IKEA products. So there, clearly, it was sort of an attempt to use the good name of IKEA and sell infringing products through this website. And similarly, there was a similar case with Mayon in Hong Kong. We can go to the next slide, please. Okay, so again, as was mentioned before, in some cases, the website that is the complainant brings a complaint against a site that is actually inactive. The fact that a site is inactive does not prevent a finding of bad faith. So sometimes individuals may sit on a site to engage in some other sort of exchanges at some point, or there may be attempts to sort of request exorbitant fee for that site. So there is also, this is one of the factors that's looked to, and the fact that it's inactive is not, doesn't prevent a finding of bad faith. So we can go to the next slide, please. Another element that's looked to, or example within this set of principles regarding bad faith, is the idea of many trademarks or trade names have no ordinary meaning. So they are sort of fanciful meanings that, other than its relation to a particular product or a particular industry, has no separate meaning. So example was ArcelorMittal, which was, I believe it was a metal company. So this, for example, is quite a sophisticated, fanciful name, and not something that you use sort of that one would just come up with. And it's associated with a distinct entity and industry. And so again, there's no ordinary meaning to this word in English or Chinese beyond its association with this trademark. And so again, this is another indicator of bad faith. We can go now to the next slide. Okay, finally, if there's no evidence that the respondent sought out the permission of the claimant, or no evidence that the claimant gave such permission, again, this is another indicator of bad faith. We can go to the next slide, please. So here, there have been some cases that I've seen where a complainant is attempting to establish bad faith or establishing rights to a particular domain name, but it's clear from the record that they've presented that they have not themselves established a trademark that predates the registration of the disputed domain name. And this has occurred in some cases. So for example, in this one particular case, the respondent registered this disputed domain name in 2013, and the complainant's earliest registration was in 2017 of its trademark. And so therefore it has no, in this case, on these facts, it had no basis to establish rights in this particular domain name. And so this is also very important, having a record of trademark registration and use that predates the registration of the domain name. All right, so I believe that we are near the end of this section, which is sort of outlining some of the requirements. We could go to the final slide, please. Or this might be it, I'm not sure. Oh, that's it. So I tried to bring us back. So I think we're back at the sort of time frame of what I was scheduled for, and I do look forward to your questions, your comments, and again, thank you to Sarah and Eugene, and to all the participants. I see there are quite a number of you here, and look forward to hearing from you later. Thanks so much.
Thank you very much, Sharla. That was very interesting, and you raised a number of points that I think we'll come back to in our discussion. We do have over 100 people on the webinar, so we're very happy to see you all. If anyone has questions, please send them through, and we'll get to them hopefully at the end. So what I want to do is just give a brief presentation on HKIAC's experience of domain name dispute resolution, because I think it's quite a special vantage point that the HKIAC as a service provider can offer, because of course we administer hundreds of domain name disputes every year. So we provide services in a range of policies, and I've got on the slide here all of those policies, but I really want to just focus on the three main policies under which we receive requests every year. The first is the UDRP, which is the policy that is adopted by ICANN for all official registrars under the ICANN policy. And HKIAC provides its services under the UDRP through its participation in the ADNDRC, which Eugene mentioned. That is the Asian Domain Name Dispute Resolution Center. HKIAC is one of 4 offices in Asia that provide services under that policy. Then under the HKDRP and the CNDRP, HKIAC provides services in its own right. Here you'll see our numbers for the last 5 years, and you can see that the vast majority of our cases are under the UDRP policy. And then we also have the CNDRP and the HKDRP, which are the next most frequently used policies for HKIAC's services. And when it comes to our services, the main difference for us between these policies, because largely the substance of the policies are the same, but the main difference for us is that when we're appointing a panelist under a UDRP case, we are appointing from the ADNDRC panel, and when we're appointing under our own right as HKIAC, we are appointing from our own HKIAC panel. The ADNDRC panel has about 180 panelists on it, and our panel has just under 100. And both panels have certain criteria for candidates to apply and be included on the list. So there you can see on the right-hand column the total number of cases that we deal with typically in any year. That's between 180 and about 235 per year. So what does a domain name dispute resolution service provider do? Our role is really a procedural role, but we come into play in a number of points in the procedure. It starts off once we receive the complaint. What we need to do is we need to request the registrar, whichever registrar it is, to lock the domain name. And that means that the status of the domain name and who has ownership over it cannot change for the entirety of the proceedings. We also, as Eugene alluded to earlier, we confirm the respondent's contact information, and that's because it's incumbent upon us to serve the respondent of the complaint. We also review the complaint for compliance with the policy and the rules. And as I mentioned, we give notice to the respondent of the complaint. We act as a conduit for communications between the registrar, between the parties, ultimately between the parties and the panelist. And we monitor the process at all points in time according to timelines. And I've put in brackets throughout this list some timelines that apply to each stage of the proceeding. And one takeaway point is that every stage of the proceeding has a set timeline. So that is a really important part of what we do, is we monitor those timelines. So for example, under the UDRP, once the complaint has been sent to the respondent has 20 days to file its response. And after that, we have 5 days to appoint a panelist. And that, I think, is one of the most important things that we do in the entire process, is appoint panelists. Just going back to the response from the respondent, it is very common for respondents in domain name proceedings not to respond. So in some ways that makes the complainant's life a little bit easier. When we appoint the panelists, we will look at the languages that are required in the proceedings. There may be just one language, there may be two languages. Very often in our cases, we see English and Chinese. We will make sure that the panelist is independent and impartial, and that they have the requisite qualifications and experience. And if, for example, the domain name is in a certain industry and we know of a panelist who has certain industry experience, we may look to that person to be appointed. Once the appointment is made, we transmit the file immediately, and then the panelist has 14 days to issue their decision. So that decision will either be to transfer, to cancel, or to dismiss the complaint. Once the decision is made, it is then upon us to notify the decision to the parties, to the registrar, and in cases of UDRP, to ICANN. Now, what's important when we notify the decision to the registrar is that the registrar will not implement the decision until after 10 business days. So if, as is in the majority of cases, the decision is to transfer the domain name, that will not happen until after 10 days. And that 10-day period is designed to allow for the respondent to file any other proceedings that it may have the right to file to challenge the decision. So it can take up court proceedings. So the registrar will only transfer or cancel a domain name once that time limit has passed and it is satisfied that no other proceedings have been taken. Then as the service provider, what we would do is we would finalize things with the panelists, we would pay their fees. And then another very important part of our work is that we would publicize the decision. And that is something that's excellent in this field, is that all decisions, with very few exceptions, are publicly available. They're available in English and in Chinese, and all service providers have this obligation to make decisions public. So there is a wealth of information available for parties. So let me now just take you through some of our statistics for last year, because it will give you a good overview of what we're doing and what we're seeing. So last year we had parties from 34 different jurisdictions involved in our domain name disputes. And you see here on the left, the top 10 geographical origins or nationalities of the parties, and the top 2 being mainland Chinese parties and US parties, and then really a spread of parties from Asia, Europe, and the US. And then if you look on the right-hand side, you will see the top 6 jurisdictions from which complainants typically come in our cases. And last year, you see that the top 2 were American and mainland Chinese, and then you have Germany, Hong Kong, Cayman Islands, and Singapore. And one thing to note about the Cayman Islands is that often there will be behind that incorporation a mainland Chinese interest. And then what is a bit more stark is when you look at the top 6 respondent jurisdictions, you will see that the number 1 respondent, the jurisdiction from which respondents come, are from mainland China. And many of the respondents that we see on our cases are individuals, and very often they will not participate in the domain name proceeding. And then far behind, you will find American respondents, and then Hong Kong, Bangladesh, Macanese, and Filipino. And then we have a whole slew of other nationalities, where last year we had 1 respondent in our statistics. Languages, it will come as no surprise, seeing where the parties are from in our cases, that the split in our cases between English and Chinese is very much in favor of the Chinese language. 2/3 of our cases, decisions were rendered in the Chinese language, and just over 1/3 were rendered in English. Even though we have many cases where the language of the proceedings is English, there will still be Chinese language elements within the evidence on the case. In a domain name dispute resolution proceeding, the language of the proceedings is determined by the language of the registration agreement, and that's the agreement between the domain name holder, the registrant, and the registrar. That, of course, can be changed by a panel if the panelist sees fit for the proper conduct of the proceedings. But having said that, in making that decision, a panelist must be careful to ensure that due process rights are taken into consideration with respect to the respondent if the request to change the language is coming from the complainant. But one thing to note that is quite interesting this year is that in addition to English and Chinese, we've also had cases in Japanese, in Korean, and in Russian. And luckily for us, we have full professional proficiency in Korean and Russian, and of course in English and Chinese, not so in Japanese. So we can provide services in quite a wide range of languages, but not every language. What about appointments? Last year, we made just under 200 appointments. No surprise that most of them were made in UDRP cases, followed by CNDRP cases, and far fewer in HKDRP cases. One thing to know, moving on to the middle pie graph, is that in the vast majority of domain name dispute resolution proceedings, a sole panelist will be appointed. That is the default, and that really goes hand in hand with this process being swift and cost effective, and also that the issues at play are the same. As Sharla outlined, you have the same test apply in each case. So there is a certain amount of repetition, and there's a certain amount of precedent, not formal precedent, but precedent that exists. And so really these disputes do lend themselves to being decided by a sole panelist, but not always. There can be some very complicated cases. What about the geographical origins of our panelists? Number one, Hong Kongers. And the reason I think for that mainly is the fact of the language requirements that we see in our cases, and the fact that we are looking to appoint panelists who have a neutrality. And so we're very often called upon to appoint panelists who have both Chinese and English language ability. And Hong Kong offers a very deep pool of specialists in domain name dispute resolution proceedings and IP law who have that language ability. Okay. We talked a little bit, or Eugene talked a little bit about outcomes, and I think that this is one of the really encouraging aspects of domain name proceedings and why it is so popular, and that is that there is a very high level of success. So what have our cases showed us? Last year there were 190 decisions rendered, and of those, 180 resulted in a transfer of the domain name. There were also 5 cases that resulted in the cancellation of a domain name. And I see we have a couple of questions on that. And those cancellations were ordered at the request of the complainant. And so they were successful cases. Across all of our cases, when I look at UDRP, CNDRP, and HKDRP, our rate of success is above 95%. And so that really leads one to wonder, well, it's interesting to think about the cases that did not succeed. Why did they not succeed? And it's quite easy to find out. And one way you can find out is that if you go on our public database of decisions, you see all of the decisions listed, and you see the result of the case listed in a chart, and you can find the cases where it was denied. And in those cases, what we saw last year was that the complainant had failed to establish that it had rights in the trademark at the beginning. So that was the threshold question that Sharla was mentioning before you get to the three elements of the test, is that you need to establish that you have rights. And in a number of those cases, the complainant was unable to establish those rights. And then in another case, the complaint failed on the bad faith test. And that is, Sharla referred to that case. That was one of the cases where the domain name was registered in advance of any trademark rights that were obtained by the claimant. So that's what we see on our cases. And now what I want to do is open up for discussion. And I just want to let you know, because I have seen this question come through, is whether or not the PowerPoint will be available. Yes, it will be available. This webinar is recorded, and the slides will be available very shortly after we've finished. But one question that we've received is, and perhaps I can address this to Eugene, is why would you seek to cancel a domain name rather than transfer it? And a slightly different question is, why would a panelist cancel a domain name rather than transfer it if the request is for a transfer? Eugene?
Thank you, Sarah. I must say it is rare for complainant to ask for cancellation instead of transfer. But one reason is that the complainant might not want to take up ownership of the domain name. In other words, the complainant wants to submit a UDRP complaint in order to stop that cyber squatter from using the domain name, but the complainant doesn't want to assume the costs of maintaining ownership of that domain name. So that's one possible reason. And I've also seen cases that where the complainant was successful in establishing the 3 elements, but in the remedies, the complainant asks for the domain name to be transferred to a related company. So I recall in those cases, the panel wasn't convinced that the related party is eligible to take up ownership of the domain name. So in those cases, the panel ordered a cancellation instead of transfer. But I must say it is quite rare for a complaint to ask for cancel, because one disadvantage is that once the domain name is canceled, it will be released to the public, so everyone or potentially another cyber squatter can come in and register it.
Thank you, Eugene. Shala, do you have anything to add to that?
No, I thought that was great. Nothing further.
I have a question, Shala, perhaps you could help on, is there a jurisdictional or territorial rule applicable in domain name disputes?
Yeah, so this is an interesting question. And one of the things that I love about working on these cases is that it is quite a transnational practice, in the sense that HKIAC, as Sarah and Eugene mentioned, is administering UDRP cases which deal with .com, CNDRP cases which deal with .cn, China related, or HKDRP, which are .hk. And so in many cases, .com or .net or .org, these are global domain names. And there isn't, from what I understand, the way these cases are administered, there isn't a requirement that you find an administrating body in the jurisdiction in which you have a domain name complaint. Rather, certain institutions such as HKIAC have been set up precisely to deal with a range of domain names that are registered potentially globally. I mean, .com, you could have domains in far-flung islands, etc. And it still can be handled successfully in Hong Kong. So it's quite an interesting and very global practice, in the sense that we see cases from various corners and with very interesting background that make the sort of examination of these cases always interesting, and always it's always new things to learn.
Thank you, Shala. I think we have time for one more question. Eugene, we have a question on the URS system. The question is, why were there no URS claims in 2019? Why is it not being used? Do you have any experience? Can you speak to that question from your practice? What are you seeing clients interested in, and how is the URS system appealing to clients, and also why is it not being used more often in your opinion?
Thank you, Sarah. One reason I suspect is, well, two reasons. One is that the URS is well known to the parties. So people might have heard of UDRP a lot, but URS relatively is not spoken about that much. So that's one reason. Another reason is that the URS is not that rapid. So it is supposed to be rapid, right? Uniform rapid suspension, but in practice, the some URS cases might still take weeks or maybe even a month for the decision to come down. Certainly, I've seen URS cases which can be decided in a few days, but my recollection is that it's not that rapid. So if you compare it to UDRP, where you can get the ownership of the domain name, then I think most trademark owners will still prefer the UDRP route.
Right. Okay. Thanks, Eugene. We have very quickly come to the end of our time, so I'm going to stop here. And I really want to thank Eugene and Shala for your contributions to this webinar. Thank you for your work and your sharing your expertise. As I said before, the slides and the recording of this webinar will be available on our website afterwards. For those of you who submitted questions that we didn't get a chance to answer, we will answer you outside of this webinar. And just finally, to let you know that we have a number of upcoming webinars that's set out on the screen in front of you. So please do join us. Those are in Korean, Mandarin, Russian, or English. And we look forward to having you with us again. Thank you very much.